I'd like to make you aware of other efforts that were made to try to get a satisfactory resolution to this matter. I wrote a very detailed letter to the Vice President of Operations. She's the boss of the nurse who fired me. My reply came from Human Resources saying that since I was no longer an employee of Blue Water Health, there would be no further discussion regarding my employment. I thought that was just a bit of a contradiction, since after I was fired, they did tell me that I couldn't talk to Blue Water Health employees about this matter, even though I'm well aware of the difference between talking about a factual matter and betraying confidentiality. I attended the Blue Water Health Annual General Meeting in 2013 and took letters for each member of the Board of Directors outlining my plight. They were taken from me by the chair of the board and distributed to each of the board members who was at that meeting. And I thought that was handled with sincerity, respect, and discretion. I later received a letter from the board chair telling me that I would undoubtedly be unhappy with the reply, that the board had been informed that my complaint had been dealt with appropriately and that a grievance had been filed. I respectfully replied that I didn't think good management was the responsibility of the union. The CEO is, I believe, responsible to the board of directors, and the managers are responsible or accountable to her. I personally spoke with Bob Bailey, our MPP. I went to see him along with another nurse whose situation was very similar to mine, and I sent him a lot of documentation regarding my situation, and because there's no way with the short amount of time we had to talk with him that I could review all of the documentation with him, but he did look at it at a later date. And I asked him to write to the CEO and see if he could get an explanation for why I was fired. Something substantial. She replied that she wasn't at liberty to discuss former employees or their conduct with him because of confidentiality. But she said, "We do appreciate you giving us the opportunity to reply with contextual background information." And then from here, the rest of the letter outlined the labor relations policies and the best practice guidelines of the hospital. I wrote back to Bob Bailey and informed him that the CEO had my permission to disclose anything related to my employment history. So I didn't think there'd be any problem in her talking with him about me and my conduct, and particularly considering that Blue Water Health does have a policy of transparency. And I also, not only as far as my situation went, but I did want a number of matters that I had written to the hospital about looked into, because I thought not only I, but other people had been treated in ways that were very condescending, disrespectful, insulting, and contemptible bullying behavior. And that such unacceptable treatment of employees could reasonably be expected to not only harm the employees and their families, but have a deleterious effect on families, patient care. Furthermore, employees who are victimized at the hand of management tend to get re-victimized should they speak out. I think there's been a lot of research done on whistleblowers and find out that that's true. Failure of higher management to investigate and to take action condones such conduct and perpetuates it. Something wrong with my tongue today. I invited the CEO to contact me by email or by phone should she have any questions, and I provided my contact information. The CEO's response was that where it was not normal practice to discuss the conduct of a former employee, she would do so in my case, since I had given my permission. So she wrote, Ms. Rondeau engaged in conduct unbefitting of the professional standards of the College of Nursing and contrary to Blue Water Health's mission to provide exemplary care, the main elements of which are compassion, quality, and safety. Ms. Rondeau's inaction, as evidenced on videotape, put a vulnerable patient at risk of harm. Well, all of that, there is no substance to what I haven't heard any facts of what I did or, what I should have done. And this vulnerable patient that was put at risk had already demonstrated her vulnerability by breaking the facial bones of a man who was much larger than her and who was in the process of being restrained by two younger, bigger security guards than me. They were having a difficult time, and they were injured from her as well. So what about our vulnerable employees? After a comprehensive review, and in accordance with normal and appropriate disciplinary process, she was terminated in January 2013. Well, I'd like to know more about what was that comprehensive review, because I didn't see any other investigation other than a video where you can see the back of my head in the crisis interview room. This is what I'm trying to find out. Why was I fired, and why have I had to go through all this? Following the collective agreement process, an arbitration was held in June of 2013, in which she and union representation participated, and there was a settlement between parties following the arbitration. Although she suggests she did nothing wrong, we disagree. If our disciplinary action is viewed as harsh by Ms. Rondeau, we make no apology for protecting patient safety. Her allegations of this organization's bullying are slanderous and simply untrue. As she is no longer an employee of Blue Water Health, we consider this matter closed. Next, I filed a complaint with the Ontario Labour Relations Board against the union because I thought I could prove that the union had acted for me in ways that were arbitrary, in bad faith, and discriminatory. I thought they had behaved in a way that was just arbitrary because they wouldn't accept my grievance as it was written on the grievance form. The only thing they would accept was the unjust termination. So I thought they arbitrarily decided to do that, and I was told that the union has the right as to what they're going to represent someone for. I thought they acted in bad faith, which means dishonestly, because whereas I had wanted to clear my name, get this matter investigated, show that I had done nothing wrong, and return to work, their goal apparently had been to settle all along. The other reason I thought I'd not been honestly represented was because right from the beginning I was told that this is a very serious case. Whereas after I'd settled, I inferred from the behavior of the union lawyer that she never really thought the union had it, or the hospital had a case at all. Because she kind of tossed her head and laughed and said it was only 3 frames. So I thought then that all along she really hadn't thought it was all that serious. So I was also treated in a way that was discriminatory, and and that the lawyer for the union didn't seem to be unbiased, as throughout she seemed to be on the side of the hospital. Yeah, again, I didn't understand that when the union lawyer told me that her client was the union and not me, that the tacit implication was that it was not my welfare or my cause that was going to be advanced, rather it would be that of the union, and it seemed that of the hospital, given that throughout the proceedings that was not clearly disclosed to me. I assert that the union was acting with a hidden agenda. That is, the union was being deceitful. Why did my union not challenge the hospital with the investigation it had done? Why was no investigation done by the union? To my knowledge, none of the employees whose names I provided were interviewed. I know with certainty that the ER physician was not questioned regarding this matter. Why, after I signed the arbitrator's agreement, was I pressured by the union lawyer to sign a document that had been handwritten by the hospital lawyer prohibiting me from taking any legal action against the hospital, when that was what after I told her that was what I intended to do, and that was what I wanted the union to do for me in the first place. So a while later, I needed to go to Toronto for a hearing at the Ontario Labour Relations Board headquarters. While I was there, an employee of the Ontario Labour Relations Board asked the union lawyer, and now a law firm representing the union lawyer, so there were two sets of lawyers there, and she asked them to leave the room, and then she tried to talk to me very nicely, and tell me that I didn't have a chance of winning anything with the OLRB, that if I continued to come back to Toronto, it was just going to cost me more money, because as it was, I had to go down the night before and stay over because the meeting was early in the morning, and this was in January. The weather was really bad. You know, gas is $65 for a round trip to Toronto. All of these expenses that I was paying for myself. Everybody else gets their expenses paid for, but I put a lot of time, money, emotion, ink cartridges into, trying to sort of clear my name. And everything's just been reduced to a power struggle. It's very discouraging. So she said, you're going to lose anyway, so you might as well just withdraw your complaint. And so she put a piece of paper in front of me and a pen. And I said, oh, I already regret signing some things I've signed. I'm going to see this through. No, I want this to go before the Ontario Labour Relations Board. I thought I had a pretty good case for the fact that I had not been adequately represented. So I wouldn't do that. So then she had the lawyers come back in, and then this lawyer for the law firm now that's representing the lawyer, she was, again, quite stern, which I can't help but think is just an intimidation tactic. And she said, well, we do not think you have a prima facie case, which means I think that I don't have enough facts to support my complaint. And I said, well, I think I do. She tried to get me to withdraw it again. I said, I think I do. And she just closed her book and turned and said, we're out of here. And then they left. So I went back home, and then a little while later, I received a letter from the Ontario Labour Relations Board, and it reiterated the points that I had made and the points the union had made, and they were reflected fairly accurately. And then the letter ended by saying that the OLRB, or Ontario Labour Relations Board, wanted to hear what I had to say. So I had then to get more submissions into the OLRB by a certain deadline. So I got to work, writing, and and I was out of town, so I had to fax everything in, which cost me $40 just to fax. So I got all my submissions in on time. Well, less than a month later, I got another letter from the OLRB, and my heart kind of skipped a beat as I saw this envelope. However, my hopes were dashed when I opened it and read all the blah blah stuff again about, he said, she said, or they said, she said. And then in the end, it just says something about that I was not, they didn't think I'd been coerced into a settlement, and that after all, I signed the settlement documents, therefore the case was dismissed. Well, they knew right in the beginning that I had signed. It wasn't about signing, it was about the way I was represented. So that wasn't even dealt with, really. And the OLRB, the last paper they sent to me, they just said, they didn't think that I had been coerced. So it was very, very disappointing and exhausting, because I'm not the only person who gets tired of fighting these battles, because it's all about process and power and politics and prestige. And what happened to fair and ethical and substantial? So, okay, that's the end of this. Cut.